I'm Rod Chappell, and thanks for joining us on the Rod Chappell Show. This is a great episode because we're continuing the last episode, if you haven't seen it, with Judge Walker from here in Cole County, who served at multiple levels of the judiciary, both as a municipal judge and now as a circuit court judge, in the circuit court system, that is. You are listening to a judge's judge as he was a lawyer's lawyer. And so this is a great opportunity. This is the number one thing that will get you thrown out of Judge Walker's court. What is it, Judge?
Well, this is applying to lawyers. Some of those other rules, obviously the rules of professional conduct apply to lawyers.
Right.
And we talked about that there's a code of judicial conduct that applies to the judges too, so it's not like we're immune from rules of professional conduct and judicial conduct. But the number one thing that will get you thrown out of my court as a lawyer is lose your law license. And I know that sounds obvious, but that includes for non-payment of your bar dues. Part of the responsibility of a lawyer is to pay annual dues. Part of the responsibility of a lawyer is to complete continuing legal education hours. We are required as a minimum of 15, and I want to talk about that in just a moment, 15 hours every year of professional continuing legal education hours by seminars and training and reading. So I've had, unfortunately, a few times when a lawyer has walked into court and I thought, I'm pretty sure that our local Missouri Lawyers Weekly or our bar notices have said, that lawyer doesn't have a license.
Right.
Well, then you're definitely going to get advised to turn right around and walk out of my court. And a corollary of that, and unfortunately I've seen this as well, is don't allow another former lawyer, someone who has been disbarred, lost their license, don't allow that attorney to appear for you or practice for you or try to communicate about the case that you are now handling.
Wow.
And unfortunately I've seen that on a couple of occasions.
Yeah.
So that'd be number one, is lose your license, you're going to get thrown out of my court.
That's right. That's right. And rightfully so. You got no business being there.
That's right.
Right?
You know, I will say that, you know, the examples I've cited and obviously talking about the rules, those are exceptions.
Yeah.
In 20, let's see, I've practiced, how long have you practiced law now, Mr. Chappell?
Since 95?
Yeah. So you've practiced almost 25 years.
Yes.
I've practiced since 1991. So you guys do the math. Who's older here?
I got more gray hair. I don't know how this is working
it
out.
hides better in mine. But in 28 years of practice, these are, and 25 plus on the bench, these are exceptions.
Yes.
You know, and not that I couldn't have come up with a top 10 list, but to say that a lawyer was disbarred and tried to practice, that's rare, obviously. One or two examples, or suspended, not necessarily disbarred. But I will say that I believe the practice of law would be better if all lawyers and judges were reminded to go read those rules of professional responsibility and judicial conduct. Those 13 canons in the preamble are amazingly important and well written, and they apply to us every day. Every day as we practice.
That's right.
And so
that's right. Fundamental.
I think that the practice would be better if all lawyers maybe read that every year.
Right. Right. Well, I mean, and that's excellent, and I'm sure that there'll be a number of folks, because, you know, whether they see us on YouTube or the public access channel or in some other venue, will be better having reviewed the rules and haven't done it in a fun way. You know,
well,
it's
law can be pretty boring, so that's true.
And those rules aren't written in a humorous manner.
They are
They're very
not.
serious.
They are not. So I mentioned that lawyers have a responsibility, as you know, and every year you have to make sure you get 15 hours of continuing legal education credits.
Yes.
There's it ends June 30th.
Yep.
It starts anew July 1. You have to report it every year. If you don't report it, you get a no-no notice.
Yep.
And there are some exceptions or extensions that you can get, but in my practice, I tried to always make sure I was obviously getting the hours, but I was getting them that are relevant.
Yes.
I didn't like the lawyers. Not that I didn't like the lawyers,
Right.
but I didn't always respect the lawyers' approach to it, who said, "Oh, it's June 20th. I got to get my hours in," and just what CLEs are offered at the end of the year. That,
Right.
to me, that's not really living by the spirit of the law, even if you're hitting the letter of the rule. So that's something that I feel is important. And on an issue that we've talked about in some of our other visits, both here and elsewhere, this year, all lawyers in Missouri have a new obligation within the 15 hours of continuing credits. For a long time, we've had a duty to make sure we have certain ethics hours
Right.
within our hours. So we might have, 5 hours on how to handle a personal injury case, or
Right.
5 hours on how to conduct electronic discovery,
Yes.
or what's one that you've attended recently that was interesting to your practice?
I did a fundamentals kind of nuts and bolts on 1983 claims.
There you go. So,
Yeah.
discrimination claims and 1983 claims.
Absolutely.
1983 references the U.S. Code.
It does.
It's not the year 1983.
No, thank goodness.
And I haven't been practicing quite that long. So you have those hours, but then you also have ethics hours. And back within the rules, we have Rule 15 and 15-05 for continuing legal education requirements. And so the new part, it says in 1505-1, and then I'll read part 2, which is the new part. So at least 3 of the 15 credit hours must be devoted exclusively to accredited ethics programs, seminars, or activities, including professionalism, substance abuse, mental health, legal or judicial ethics, malpractice prevention, explicit or implicit bias, diversity, inclusion, or cultural competency. So that part of the rule has been in effect for a while.
Yeah.
So at least 3 hours have to hit on something that fits that definition. As of this year, we have a new requirement, part 2 of that says, and at least one of those 3 ethics hours has to be devoted exclusively to the explicit or implicit bias, diversity, inclusion, or cultural competency.
Wow.
And with your help and a few conversations, as well as Judge Epps, who sits here in our federal court in Cole County, in the Central Division of the Western District, is that right?
That's right, that's right.
Of our federal court, Judge Epps, that I've consulted with a little bit. I'm actually presenting on that issue to the Government Practice Institute next Friday.
Excellent.
And they put me as the last hour of a full day of CLE, knowing that this is a new requirement. And the lawyers are going to have to get it.
They're gonna
So I don't know whether I've made it quite as interesting as a top 10 list, but I'm going to present on that next Friday. And I think that's vitally important.
Yes.
To the lawyers, but also to the public, to know that lawyers are compelled to think of those things.
Right.
And not to be too heavy, but we talked earlier about how the rules of professional responsibility or conduct are not written in a light way, and thankfully they're not.
Well, right. It's very serious.
And in fact, the 13th canon in our preamble starts with this line that I think is fabulous. It sounds like it comes from Hamilton. I mean, it sounds like it comes from the authors of our Constitution, Jefferson or Madison or someone. It says, this is in Missouri's law rules of professional responsibility. It says, lawyers play a vital role in the preservation of society. Lawyers play a vital role in the preservation of society.
Yes.
That's heavy.
Yeah,
I mean,
let that soak in a little bit.
And true believers.
Yeah. That's right.
My experience is most lawyers that we practice with, I call them true believers.
Yeah.
They take that to heart, whether they read that every year like we suggested or not. They do take that to heart. They know that it's not just get a case in, make a couple bucks, get a case out.
Right.
They know that it's not. But that is that's heavy language that I hold dear, and I know you do in your practice. But
oh, absolutely,
and
absolutely. And you know, it's funny. You think about other references. Sometimes literature. You remember Shakespeare. First thing let's do, let's kill all the lawyers. It wasn't so much that they hated lawyers, but they knew that it was the lawyer's role within the society to uphold the rule of law, which gives rise to justice and equality and other democratic and moral concepts that I know that we believe in.
that's exactly right.
Yeah, yeah.
I remember in law school having that argument with people.
It's surprising.
It's like, I hope you don't pass law school.
Right, you don't need to be a lawyer. No, it's a joy every day to be able to practice law. You know?
Yeah.
Love the work and love being able to have the law as a tool to ensure that people in society can remain civilized, can express themselves in appropriate ways, seek remedies to injustices where those are necessary, or fight wrongs where they perceive those to be. And it's these rules help keep it all in line, not only to make sure that the lawyers work on behalf of the people and demonstrate that to them daily, you know, by their conduct and by the manner in which they conduct their business, but also to ensure that we as lawyers don't become tools in someone else's chess game,
Absolutely.
you know, that has some nefarious purpose. Now, that's not to say that people with lots of money can't hire lots of lawyers and you know, get their whatever it is that they're trying to get accomplished. But at the same time, if you've got rules, that's due process, right?
Absolutely, due process is perfect perfect reference. And there are several references in the rules, and I may not have made a direct reference to them today, that talk about our responsibility as a lawyer, and certainly as a judge, is to assure that others comply with the rules and the laws. And in fact, judicial conduct has a specific section that says the judge shall assure that everyone practicing before them does so in a way that doesn't exclude. So inclusion that keeps to mind. I can't find the exact citation, but that here it is. They shall aspire to conduct that assures the greatest possible public confidence in their independence, impartiality, integrity, and competence, and all lawyers who appear before them do the same. I mean, that's our obligation.
Yeah.
And I take that seriously, and I know you do. So.
Oh, absolutely, absolutely. Well, you know, it's funny. We've been at bar functions, you know, where the lawyers get together. They call that the Cole County Bar Association, just a lawyers group, and other groups too. But I think I enjoy our times when we're somewhere in public, and it's lawyers appreciate judges, and that's good. But when the people, you know, go out of their way to say hello, I think that shows not just a level of respect, which is certainly appropriate, but knowing that there are expectations and feeling like everybody's meeting those, you know, that's the role of a judge. And it is heavy. It's big in a society. It's really big, you know. So we talked about lawyers a little bit. What's the top 3 things that litigants could do to reasonably get kicked out of your court?
Well, I'll try and do it in the same way. So number 3 is dress appropriately.
Okay, right.
I know that seems simple, and that can be obviously don't dress like you're going to the club. Don't show too much skin.
Right.
It's also don't wear T-shirts that have messages. This just happened this week.
What was it?
Somebody had a T-shirt on, a jacket that was open, and the T-shirt, while they were appearing on a drug possession case, said, "I have problems." And I don't think it was a cry for help.
Right.
Although we try to help all those.
No, absolutely.
But I literally thought to myself, sometimes the script writes itself.
Yes, it does.
I've seen worse T-shirts. This happened. I was appearing in Greene County years ago, so Springfield, Missouri, And I was awaiting an appearance on a civil docket, and a criminal docket was finishing up before me. And I kind of wasn't paying attention at first until I saw the judge's demeanor change and really starting to, talk to this defendant who was standing there with their poor lawyer in this case. And it was because as the litigant approached, the judge looked up, and he was there on a sentencing hearing on a criminal matter, and his T-shirt said, "You and what army?"
Oh, nice.
And the judge is like, well, here's the thing. I'm wearing a robe. I don't need an army.
Right?
And here's the sentence. And it's enhanced because you made that choice.
Yes,
I mean, so your attire is one of them.
It's
Number two, I would say, kind of is what we talked about with some of the responsibility. Don't abuse court staff, obviously the judge, and that could be something as simple as cursing at them, not abiding by the decorum of the court. I mean, that's in our rules of professional responsibility, but it's expectation, and a judge has the obligation. That's kind of like number 5, don't put the judge at risk. I have an obligation to everyone to assure decorum of the court, impartiality, and that everyone's getting their due process.
Right.
Well, how is that going to happen if you're in the back of the room screaming at my bailiff?
Right. That's right.
Or not abiding by something as simple as turning your phone off. I mean, that's so that'd be another one.
Yeah.
And then the number one, and this is hard, and I think it is why sometimes what makes a difference in a good, thorough judge who's paying attention, and maybe one who isn't as wary, because it's hard to sometimes read. But number one for the litigant is be honest.
Right.
Tell the truth. Obviously, when we put you under oath, which if we're having a trial or a contested hearing, we're putting you under oath or a plea or something. But there's lots of appearances where I don't put you under oath because it's your first appearance. I'm reading you the charge. Your due process is to hear what the state is claiming so that you know what you're charged with. That's in the Constitution and in the Bill of Rights. But then if you're not going to be truthful, sometimes it's very simple things, and sometimes it's very intentional things. I sometimes, this is sort of a funny one, but I understand when litigants are nervous.
Sure.
I get it. And this is not just criminal defendants, sometimes civil defendants. When they appear and they say, well, to tell you the truth, Your Honor, and I go, wait, time out. You're in court.
Right.
I hope you're telling the truth.
Yes.
But literally, number one, so of 3, 2, 1 would be tell the truth.
Yeah.
I mean, I'm there to do justice, to make sure justice is done, and I'm not on your side or the state side or the other litigant's side. I want to know the truth.
Yes.
I take very seriously my role in what is justice. And without the truth, I can't get there.
That's right.
And so back to the reference about judges, and I didn't want to make it about that, but I feel like I'm pretty good at reading that and stopping the litigant who might start to perjure themselves or something like that. But so advice to litigants who appear, tell the truth.
Absolutely.
And know that as a criminal defendant, you of course have the right to remain silent.
Right.
And the court or a jury can't make any assumption about that.
That's right.
But don't lie. And if the only way you think you can't lie is keep your mouth shut, then be silent.
Quiet, yes.
It's your constitutional right.
Right. Well,
So that'd be number one.
That's huge. Because you're right. The system, it depends on people being honest. And, there's one thing about it. It's been around for hundreds of years. If lying was the way to get around the system, it wouldn't be the system, right? It's always going to get found out, and usually it's going to be a lot worse and probably a lot of headache and heartache for everybody, one that always kind of surprises me, and I've had this happen a couple of times, clients who have some kind of a substance abuse problem, so they'll come in and they smell funny. I'm like, boy, this is not going well, or they're slurring because they're, had their morning drink or whatnot. And that's always, it's a sad situation for the person to be in, that they can't stay sober for a little bit. And then, of course, making sure that they're competent
Yeah.
with whatever assertions they have to do that
Correct,
day, or participation, and so that's always hard. Wow.
Yeah,
Wow.
unfortunately, I've seen that a few times. Yeah.
I suspect. Yeah, and of course the dress part. And I've been to, certainly was there in municipal court on a number of occasions, and I've seen folks come in with their weed T-shirt. Now, weed is going to be probably legalized at some point, but at that point it sure wasn't. And so coming to court with the shirt, your contraband shirt, and your flip-flops, and
While you're charged with an offense related to that,
might not be the way to go. Might not.
to me, that is not remaining silent.
That's right. Yes. Hey, there's lots of forms of speech, right?
That's right.
Yeah.
That's right.
Yeah. Wow. Well, it's I tell you what, I will certainly think a lot deeper about our responsibilities as a judge, as being a custodian of such an important value as justice within our community. And
you served. I mean, you previously served as an administrative law judge, as a presiding on a tribunal situation, and so you knew that you could tell the lawyers and litigants who were complying or were perpetually tardy, perpetually unprepared, arguing things not in evidence of the law. So you have that experience as well.
Oh yeah, I remember one young man who had worked for the Attorney General's office, and I think it was about the third time he didn't show up for the hearing. I mean, just flat out didn't show up. I thought, there's got to be something. We have to talk about this.
Yes.
And he got better. He was having a very hard time, which you might expect. But yeah, it's a huge privilege, great honor. I want to say thank you, Judge.
Well,
Thanks for taking the time.
Thank you for letting me be here again.
Oh, absolutely. And having been here before, we'll expect for you to come back.
Yes, sir.
Yeah. Public service is a heavy weight. It is not a life sentence, but it's certainly an honor to do it every day, and you bring honor to the work.
Thank you very much.
You're welcome. Thanks for joining us on the Rod Chappell Show. It's been a great joy to have Judge Walker on to hear about some of the things that you would never expect to see in court. And as a litigant, as a person who hires a lawyer or has a lawyer that's working on their behalf, you probably won't see even one or two of the things that we talked about on this show. Chances are you probably won't. If you do, for example, if your lawyer hits you or something, you'll know this is not normal and I don't have to put up with it. And at the same time, you should know that your visits to the courthouse, you should be treated with respect and dignity and behave in the same way. So thank you for being on the Rod Chappell Show. We look forward to having you again.